I mean, criminal litigation review after the final decision is the general rule. There generally is not any interlocutory appeal, and what you say could happen in any criminal case if you assume bad faith on the part of the people who are responsible for making the decisions along the way. They could delay indefinitely and postpone the entry of a final decision.
Justice Alito, if this were a final, if this were like a criminal proceeding, we wouldn't be here. The whole point of this is to say we're challenging the lawfulness of the tribunal itself. This isn't a challenge to some decision that a court makes. This is a challenge to the court itself. And that's why it's different than the ordinary criminal context that you're positing. In the ordinary criminal context you're positing, and I'm thinking of a case like Schlesinger versus Councilman, a court-martial case, what the court has said is that it's the predicate for abstention is the idea that Congress has fairly balanced the rights of both sides, an independent branch, and has made certain determinations. Here, none of that has happened. It's all been made by the executive. And the difference is crucial in military justice because, as Justice Kennedy said for the court in Loving, the framers harbored a deep distrust of military tribunals. And the thing that makes it different than the ordinary criminal context, the thing that, as this court said, stops military justice from being lawless, is the Congress of the United States setting clear limits on the use of military justice. Now, if those limits had been observed, if the military commission complied with the rules of courts-martial, we wouldn't be here. Our whole point is that they don't, and that it falls outside of the well-recognized abstention exception for courts-martial cases. In addition, we believe that to further on Justice Alito on your point, this court has already said in the military commission context that a different rule applies. In Kieran, this court rushed in to hear a military commission challenge before the commission was over, and the reason why it did so was it said that the public interest required adjudication of these issues, and the public interest is no less severe in that case than it is here. That is, this is a military commission that is literally unbounded by the laws, Constitution, and treaties of the United States. And if you adopt the government's position here, it effectively replicates the blank check that this court rejected in Hamdan.
Could I come back to Justice Alito's question as to what the normal procedure would be in criminal cases? Suppose you have a challenge to the makeup of the tribunal in a criminal case. Is it the normal practice that you would get to raise that challenge? Let's say one of the judges is disqualified or for some other reason. Can you normally raise that challenge before the criminal case is final?
I don't believe so.
So there would be nothing different in this situation if you couldn't raise it until it was final.
Justice Scalia, everything is different about this. That is, in your posited hypothetical, there is some law that you know will govern that ultimate question about disqualification or whatever the matter is.
The merits of the issue. I'm just talking about the timing of the issue.
Well, I do think that there's an integral relationship between the two. That is, that the predicate for abstention has always been that Congress or some other entity has fairly balanced the rights of both sides. Here you don't have that fundamental guarantee. If you adopt the government's reading here, they've said that they want to try 75 military commission cases or so in the first wave. You will then be left with 75 trials that take place without even the most basic question of what the parameters are that these commissions are to operate.
Well, hasn't fairly balanced it. I mean, I guess that depends upon your reading of the statute. If indeed you read it the way the government reads it, they would assert that Congress did consider these military commissions and thought that it was okay to wait until they had completed their work before full review is provided. I mean, it's sort of you're running in a circle.
Well, that's precisely, Justice Scalia, our argument, that I don't think one can consider the abstention claim, and this is what I believe both courts below had held. You can't consider the abstention claim without deciding the underlying merits. And if you believe that the Congress has fairly balanced the rights and are compliant with the UCMJ and the like, then I don't think then you're reaching the holding. So if I could turn to the merits challenges. The first thing I'd like to discuss is question number 1, and whether this military commission states a charge that violates the laws of war. And we believe it doesn't for 2 essential reasons. First, the only charge in this case is one of conspiracy, and conspiracy has been rejected as a violation of the laws of war in every tribunal to consider the issue since World War II. It has been rejected at Nuremberg. It's been rejected in the Tokyo tribunals. It's been rejected in the international tribunals for Rwanda and Yugoslavia. And most importantly, it's been rejected by the Congress of the United States in 1997.
Mr. Condi, will you help me? Where is the conspiracy charge in the papers?
The charge itself, Justice Stevens, is found at 63A of the petition appendix.
Okay, thank you very much.
Sure. And
suppose you had a tribunal that was properly constituted as you contend that it ought to be, and then the charge was conspiracy. Would the courts then have review before the trial proceeded? And let's assume that it's conspiracy in some other charge. Is there some analog in ordinary criminal proceedings where you challenge in advance the validity of the charge?
Ordinarily, Justice Kennedy, the answer would be no. You wouldn't challenge the validity of the charge. And indeed, I think Councilman itself is a case in which there was a charge at issue and the question was subject matter jurisdiction. The reason why this is different, however, is twofold. First, the claim that Mr. Hamdan is making is that conspiracy itself falls entirely out of any authorization of Congress. In Councilman, the question was, there was an Article 134 of the UCMJ, which was a criminal statute, and it had been interpreted to punish drug dealing. And in the case, the court said, this court said, we will defer as to whether the facts showed the requisite amount of drug dealing to violate the Uniform Code. Here, by contrast, Mr. Hamdan's claim is that the conspiracy charge falls entirely outside of the laws of war as a whole.
Could the tribunal interpret the conspiracy charge to mean joint enterprise, which would be closer, at least, to accepted practice in the international tribunals?
The charge itself is one of conspiracy. Joint enterprise is itself not an independent charge in international tribunals. So you can charge, for example, murder, and your theory in an international tribunal of how you get to murder is joint criminal enterprise. But you'd have to charge the underlying violation itself. Here,
I'm still not sure why, if we think that there is merit to your argument that the tribunal is not properly established anyway, that we have to reach the conspiracy charge. If we think that you're wrong on that, I don't know why that court can't hear the conspiracy argument.
Well, there's 2 different reasons. The tribunal's not authorized and that the charge doesn't state a violation. Now, even if we assume that the tribunal is authorized and that all of its micro-procedures are authorized under the Act of Congress, allowing this charge, conspiracy, is to open the floodgates to give the President the ability to charge whatever he wants in a military commission.
Mr. Kerry, I mean, that's a good argument from a broad policy, but isn't there a narrower reason? If we assume that the commission is properly established for some purpose, by definition, that purpose is limited. We are not dealing here, as we would in the normal criminal case, with a court of general jurisdiction. If we're dealing with a court of general jurisdiction, we postpone claims like yours till the end because we say the jurisdiction is so broad they probably had it. Maybe not, but we can wait. But in a court of limited jurisdiction or a commission of limited jurisdiction, we can't indulge that presumption. And that's why I thought your claim that conspiracy is not cognizable can be raised at the beginning because it's inseparable from the limited jurisdiction of the court. Am I off in left field?
You are absolutely correct, Justice Souter. And in